So Blake Lively has just filed to be dismissed from the lawsuit Justin Baldoni filed against her. And there's a new California law that may help her get out of it. But I have some information that it may not work out in her favor. So if you have not heard yet, yes, Blake Lively has filed to get out of this lawsuit. And this gets tricky because it applies to a new law in California that was actually enacted in January of 2024. Now, on its face, it can look like that she could get out of it, but there are some details in which I don't see how that's a possibility. And it also doesn't mean Justin Baldoni can't sue her again, but let's get into it because I don't want to piss you off so early in this video. But it says Blake Lively files motion to dismiss Justin Baldoni's vengeful lawsuit citing this California law. Plus, what ends with us star Jenny Slate had to say when asked about the Lively Baldoni drama. I may save that for a different video because there's a lot to get into. So Blake Lively filed to dismiss Justin Baldoni's $400 million lawsuit. The move comes 2 days after her husband, Ryan Reynolds, asked the court to do the same. In the motion to dismiss, Lively's legal team cited a California law that protects individuals from retaliatory lawsuits if they report allegations of sexual harassment or misconduct. If successful, Baldoni could be on the hook to cover Reynolds and Lively's legal fees. This lawsuit is a profound abuse of the legal process. This is what's in this filing. So this lawsuit is a profound abuse of the legal process that has no place in federal court. California law now expressly prohibits suing victims who make the decision to speak out against sexual harassment or retaliation, whether in a lawsuit or in the press. Attorneys Mike Gottlieb and Ezra Hudson told Yahoo Entertainment in a statement. This meritless and retaliatory lawsuit runs headfirst into three legal obstacles, including the litigation, fair report, and sexual harassment privileges, the latter of which contains a mandatory fee-shifting provision that will require the likes of billionaire Steve Sarowitz, Wayfair Studios, and others that brought frivolous defamation claims against Ms. Lively to pay damages. Gottlieb and Hudson continued. In other words, in an epic self-own, the Wayfair party's attempt to sue Ms. Lively into oblivion has only created more liability for them, and deservedly so, given what they have done. I know, guys, just keep on watching, okay? Hold on. A spokesperson for Lively said, "It's a painful reality that the actress is not alone in being sued for defamation after speaking up about being sexually harassed at work. While Ms. Lively has suffered greatly by speaking up and pursuing legal claims, it is important for other people to know that they have protections and that there is a specific law that expressly protects them from being silenced or financially ruined by a defamation lawsuit because they had the courage to speak up." The rep added, citing California's recently enacted AB 933 that gives victims legal protection. Lively's motion, which was obtained by Yahoo, slammed Baldoni's vengeful and rambling lawsuit. I mean, just reading this, it is like venom. It is so disgusting, especially with all the evidence that we know. And just the idea that someone can just claim harassment falsely, ruin someone's life, or falsely claim sexual assault, ruin that person's life, and that person should just lie down and take it. There's nothing can be done about it. It's absolutely insane that this law, I understand why the law was done, but when you think about it, like, you can just this is how people can get ahead. They can just threaten somebody and say, I will claim that you tried to sexually harass me if you don't do what I want, which is essentially what happened in this case, what I believe and what most people believe. And then you look at the text messages, how she took over the movie. You look at all the interviews of her, and then you have Ryan Reynolds saying that Justin Baldoni is just thin skinned if he can't take him harassing and bullying and making fun of him and killing him in the Deadpool movie. Like when you combine it all, it's enough to make you like completely crash out on how, I guess, delusional that these people are. And the fact that they think that this is going to cover them is insane. I cannot wait for Brian Freeman's response to this. But it says that his vengeful and rambling lawsuit, which it is not, it is very clear. The complaint claimed Baldoni's countersuit is a profound abuse of the legal process that has no place in federal court. It also called out Baldoni and his co-defendants' bizarre theories about the actress's intentions. On the one hand, the Wayfarer parties insist that Miss Lively is an immensely powerful Hollywood superstar who, along with her influential husband, wielded power to steal creative control over the film. But on the other hand, they claim she was so powerless that the only way she could have any power was by manufacturing sexual harassment allegations almost a year in advance in a Machiavellian long game, the complaint stated. These two concepts contradict each other and therefore cannot coexist. They're not saying that she was powerful, that, yeah, her husband's powerful and that she's more powerful because of her proximity to Ryan Reynolds, because of that relationship, because he's an A-lister, and Justin Baldoni, most people don't even know who he is, or they didn't know before this lawsuit. But they're trying to pull two different things that are within that lawsuit and saying they contradict each other, but they don't. A person can be powerful in essence, but also feel powerless or create a scheme to take over a movie in order to grab power. You get that? To get more power for themselves. So they're not claiming she was powerless. They're saying that she tried to get more power by doing the different things that she did well in advance. And she's even said that this is the thing that she likes to do to a director. She pretends she's going to come in and be just an actress, but she has to have agency, control. She's going to start to take over the movie, the project, and what she describes specifically as a rug pull, meaning pulling the rug from out from under them. Like how the saying is, and you pull the rug and the person falls. That's essentially what she said that she does when she was in an interview. The complaint once again reiterated many of Lively's sexual harassment allegations she claimed to have experienced while filming It Ends With Us. It alleges that Baldoni's lawsuit is full of admissions and that the incidents underlying Miss Lively's sexual harassment claims occurred. It doesn't. Some of the examples set forth are that a simulated nude scene was filmed without an intimacy coordinator present, that she refused to meet with and did not want. Okay. And Baldoni discussed orgasm while having sex with his wife and that he improvised while filming romantic scenes. Guys, this is full of BS when you put it into the context of what was going on the film and how they were trying to, get these scenes done. This is the same woman who claimed Jamie Heath showed her pornography because they were trying to figure out the birthing scene, and he showed her pictures of his wife's home birth, her water birth, and she labeled that as being shown pornography. So on its face, this sexual harassment that she's claiming, which she did not use the right channels if she was being sexually harassed in order to resolve this. So she actually violated California law by not doing it, by not going to Sony, by not going to higher ups. And then we saw these complaints to Sony, these HR complaints magically appeared one day with everything redacted. We don't even have a date when these were filed. But again, guys, we know the evidence. Hopefully, you know a lot of the evidence and know that the things that they're saying. And this, to me, seems like yet again, another desperate grab to get out of accountability and also to try to spin the narrative. Because while people like you and I are invested in this case, the average person may just scroll past headlines and not dig into the merits of it or actually see all the evidence. So it's a way to get the public back on their side, or at least the people who are not paying attention to this case. Let me see. Okay. All right. And then that's getting into Jenny Slate. So I want to show you something really quickly. So while I was listening to kind of like this, some lawyers talk about this at Ask Two Lawyers, and I was listening to them go over it, and just they kind of go over what is in the actual filing. This is something that really stood out to me. So if you look here, and people are outraged. Let me see, where is it? Let me scroll down. Okay, here it is. HR here at the location of the employees, and I'll make it bigger. Where is it? And guys, if you have a baby, just ignore her. She's been washed and cared for. She's just happy. HR here, the location of the employee is the law that applies. If it's a New York based employee, even though I'm an Illinois based company, we have to abide by New York law for workplace conduct. And even the lawyers say good input. Now, this is where you have to dig into the weeds. I'm going to show you something that this says, and how, in my opinion, this does not apply to this case. So it says a communication made by an individual without malice. Without malice. She would have to prove it was without malice when she filed these sexual harassment complaints with California. And this is the thing. The entire filming of It Ends With Us was filmed primarily in New York and New Jersey with a few other places, but none of it took place in California. And she filed the complaint in California, but the harassment, the alleged harassment that she underwent, took place on set while filming in New York, in New Jersey. So California law doesn't even apply. And her even filing it in California can be looked at as erroneous. It should have been filed in New Jersey or in New York, where she actually was located, where she was actually employed, and where the sexual harassment happened. I can't be working in I don't know, Denver in Colorado, right? Even if the company is based in, let's say the company is based in Utah, right? And then, but I'm working in Colorado. So my company is based in Utah. I am working in Colorado, right? The alleged harassment happens in Colorado. Okay. Everything happens in Colorado. That's where I'm actually working. That's where my employment is taking place. I can't then go all the way back to Utah and say, now I'm going to file this complaint. It has to be filed within that state. All right. So that's the first thing. But then when you see without malice, she's going to prove that this harassment happened. You can't just say it happened and you have no evidence of it, which she does not. It's just her saying it. And then as you look at all the evidence in the scheming and the text messages and all of the things that Justin Baldoni has filed against her, you can see how she was trying to take his movie away from him. Okay. This is what he's saying. This is what most of us believe. So the malice there is that she's making these complaints falsely. Okay. So it has to be without malice. And in this case, it does not count. Now we have to see what Brian Friedman files to kind of unpack this. But that's the first thing that stood out to me. So, but it says without malice regarding an incident of sexual assault, harassment, or discrimination is privileged under Section 47. Okay. And this talks about how a prevailing defendant in any defamation action brought against the defendant for making a communication that is privileged under this section shall be entitled to reasonable attorney fees. So when they say they're making a communication that is privileged, what does privileged mean? Because when I say when it's privileged, it's something that's supposed to be private. right? Something that is, or something you talk about with your attorney-client privilege. When you file a harassment complaint, that is privilege for the protection of the person until an investigation has been done. I don't even know if California has investigated this. Okay. And I don't even know if they are allowed to, based on where all of this took place, all the things I just described. So we need to understand what privilege means. So privilege under this section shall be entitled to the reasonable attorney's fees and costs for successfully defending themselves in the litigation, plus tremble damages for any harm caused to them by the defamation action. Sorry guys, I'm scrolling two different places for the defamation action against them, in addition to punitive damages available under section, okay, blah, 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 blah. This section shall only apply to an individual that has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. So when you look at this, she said it's a reasonable basis. Reasonable basis. This is where she's going to be in trouble as well, because if she had a reasonable basis to believe that she was being sexually harassed to the degree that she's talking about, she should have followed the correct channels, not only the channels with Sony and the studios in filing these complaints. There is a whole thing that has to be done when you file a sexual harassment complaint with HR at a company that you work for or doing work for. There are procedures. They have to investigate. There has to be so many different steps that are taking place in order to prove that this actually happened. And she never did that. Also, she would actually have to do this under the Actors Guild. Okay. If she is being sexually harassed at the workplace on set, this is something that would have to be filed with them. So was it reasonable what she's thinking, or she filed this well after the movie was done, well after production, and then poof, magically, this just appeared out of nowhere. Okay. And we're talking about months and months and months. This is after the film came out. It may be even a year or so, since it is a year, over a year between her filing this with California and then the alleged harassment that she said took place. And if that's the case, and because she did not go through the proper channels, it is not reasonable to believe that any of this happened. That 17-point list that when they came back to film, that they wanted Justin Baldoni to and Wayfarer to agree to, they just agreed to it because they're like, nothing's happening. Nothing's happened. She just made the list of demands without alleging these things had happened to her on set. Because again, if they had happened to her, it was reasonable and it was the proper channel for her to report this to HR, again, to the different production companies involved, as well as the Actors Guild. Continuing. So right there, I for these two, the malice and this reasonable, I'm sorry, and the privileged, because she is the one that put that information out there, and then the reasonable, she does not meet those burdens. For the purpose of this in my opinion, I am not a lawyer, but just as a normal person looking at this is how this reads to me. For the purposes of this section, communication means factual. They have to be proven as facts that the alleged harassment she's claiming actually happened. The factual information related to the incident of the sexual assault, harassment, or discrimination experienced by the individual making the communication, including but not limited to any of the following: an act of sexual assault, an act of sexual harassment, an act of workplace harassment or discrimination, failure to prevent an act of workplace harassment or discrimination, aiding, abetting, inciting, compelling, or coercing an act of workplace harassment or discrimination, and an act of retaliation against a person for reporting opposing workplace harassment or discrimination. So what hers falls under, I'm believing, is she's claiming that this is an act of retaliation against her for filing this. Okay. So this is the retaliation. But again, you can't just take these things in isolation. You have to look at the full law, okay, and see what applies. And right now, I'm not seeing anything that applies. So it says an act of harassment or discrimination or an act of retaliation against a person for reporting harassment or discrimination by the owner of the housing accommodation. And this is okay. This is for the housing accommodation as described in section. So I'm thinking that this something happens, an apartment or something, and you're being sexually harassed by that, and it's some type of discrimination. Because again, this isn't just about sexual harassment; it's about discrimination. So was the discrimination at you couldn't get a apartment because, and you can prove that they discriminated against you, or you can prove that your landlord was sexually harassing you and then tried to maybe kick you out of the apartment because you didn't go along with it or tried to sue you or do something else. So that's what I'm thinking that refers to. And then they're doing that. And okay, an act of harassment or discrimination or an act of retaliation against a person for reporting harassment or discrimination. So he is not doing an act of retaliation against her for reporting it. That's not what it is. This lawsuit is saying, he's not saying I am, it's a retaliation to, because she did this, I'm going to just sue her, and there's no merit to my case. When you look at his case, you look at the evidence, all of the evidence points against her and the evidence points to him. So he is actually suing her for the defamation and the lies, and it ties to the New York Times and just trying to take over the movie. Those are the details. Again, guys, I don't want to make this video too long, because then in subsequent videos, I can hopefully break this down a little bit better. And I'm really hoping that Brian Freeman speaks out so we can get his take on this. Then they're talking about a classroom, and then act of cyberbullying of cyber sexual bullying as defined in that section. So this is why I've just laid out to you multiple reasons why this does not make any sense, what she's filing, and she's trying to shoehorn herself into this law as though it applies to her. But again, just to reiterate, she was not even in California when the alleged harassment took place. It took place out of state where she was employed to work. None of it happened there. She did not follow the proper channels. If this true sexual harassment was going on in the workplace, she did not report it to the higher ups, according to what we're seeing, the evidence we've seen so far. And Sony themselves said they never had a HR complaint. And so when you look at that, she didn't follow those channels. I haven't heard anything about the Actors Guild having anything filed. At least she didn't have it in her lawsuit. We don't see what anything that happened in order to the HR did anything to manage this. If this was something that was going on, things continued as normal. And even after they came back to film and they made Justin and Wayfair agree to this 17-point thing of things that would not happen on the workplace, which it wasn't. So they're like, okay. When she came back, she said nothing else was wrong after that, and everything was perfectly fine, and it was resolved. So then she's contradicting herself there. And then there was something else in here, and I'm trying to remember what I was saying. Oh, we have the malice. So it has to be found that she did not do this without malice. I think there's more than enough evidence to show malice on her part, as well as Ryan Reynolds, as well as what's her name, Jenny Slate, not Jenny Slate, the PR lady. I can never remember her name. And then we don't know what is the privileged. Okay, what is this privilege? Does this communication falls under privilege? Did she hire an attorney before this to file this? Like, we don't know. Like, in her communication to the New York Times was not privileged. That was not privileged communication. They publicized this before an investigation even took place. And the New York Times were stating it as that it's fact. Megan Twohey, and I was the first person to point this out months ago, she said that this is what really happened, stating it as a matter of fact and saying that she combed over thousands of documents, okay, and text messages. But then they also say that it's just based off of her complaint, which cannot be true, because when you see the text messages and all of that. So she did not allow the proper channels or investigation to take place in California. But then we go back to, is it even proper to be in California? And then the reasonable basis. I think the evidence shows clearly there was no reasonable basis for this. And that also ties to HR, because if you had a reasonable basis to believe you were being sexually harassed to the point that your husband created this whole nice pool character in Deadpool to dunk on Justin Baldoni and all the other things that happened, how how is that reasonable? That there's no way that you believe you were being harassed, and that's the route you take versus going the legal way, the proper way, going through the proper channels. And again, this should have been done in New York or New Jersey. And that here it is, the factual information does not line up. So you can't just lie and say that this happened and, oh, you can't sue me now for lying about it and then putting it out there to the public before an investigation has even been done or started or concluded. The investigation couldn't even have started. They just received the paperwork on the 20th. The New York Times article came out on the 21st. So, with that, guys, leave a comment. Make sure you guys are subscribed. And more than ever, I always show this to you guys, but I'm going to show it again because we have got to buckle down. Things are getting serious with this. I can't spell my own name. I'm trying to show you guys the website. Go to realmelanieking.com and pick up some of my Team Justin merch. I created these designs exclusively here by me. There's a lot of hard work, so I appreciate any support you guys can give me. I have my Justice Dragon and also my It Ends with Court. Make sure you are following me on social media, particularly on X and TikTok, where we are seeing a lot of bots trying to come for all types of content creators, and we're seeing like videos being taken down, and there's glitches in your videos now when you talk about Blake Lively or Ryan Reynolds or anything about her, or they're trying to say that you're bullying or harassing them by talking about the case and giving your opinion, which is absolutely a lie. So if you want to support me, make sure you check those out, and I will see you on the next one.